next on our agenda is, as Professor Tony mentioned, a keynote speech from a very one of the most prominent international law figures of Thailand, and if I may, of the world. We are very honored to have a kind presence of Professor Dr. Surakiart Thai, whose international law scholarship is highly acclaimed throughout the years. A brief introduction among the long list of his achievements. Professor Dr. Surakiart is a former Deputy Prime Minister and former Minister of Foreign Affairs of Thailand. And he was also an ASEAN candidate for the position of the Secretary General of United Nations in 2006. He is a former President of Asian Society of International Law in 2015 and a former Dean of Faculty of Law, Chulalongkorn University. His exceptional education background includes LLB from Chula, Master of Law and Diplomacy from Fletcher School of Law and Diplomacy, Tufts University, and LLM and SJD from Harvard Law School. And he is currently a chairman of the Asian Peace and Reconciliation Council, APRC. Today for us, he will give a keynote speech on the title, Changes in International Political, Economic, and Technological Landscape, Challenges and Opportunities for International Law Teaching and Research. Well, just reading the title is already exciting. So ladies and gentlemen, without any further ado, please welcome Professor Dr. Surakiart Thai. Please, Professor.
Sawadee krab.
Sawadee krab.
Thank you very much, Dr. Phawat Satyanarak. So glad to see you again. Assistant Professor Dr. Parina Siwanit, Dean of the Faculty of Law, Chulalongkorn University. Dr. Nilofer Oral, Director of the International Law Center of the National University of Singapore. Professor Anthony Angie at NUS Center for International Law. I'm so glad to see you again, Tony. It's been a long time, although virtually. I recap everything you said about my meeting when I was Dean of the Faculty and when we worked closely together when I was President of the Asian Society of International Law from 2013 to 2015. In fact, had I known that you would be present, I would have told Dean Parina to invite Tony to be a guest speaker and I will be a normal participant. Distinguished speakers, faculty members, students, participants, ladies and gentlemen from Thailand, Singapore, Laos. It is indeed my greatest pleasure to be invited by the organizers to deliver a keynote address at a workshop on teaching and researching international law in Asia. The topic is indeed very timely for us to examine the teaching and research of international law in the middle of fast-changing world. Dean Parina, I have to commend your ability to implement your policy of internationalization of legal studies very effectively. I am glad and heartened to hear that when Dr. Phawat consulted with you, you gave him only a day and a half or two to say yes and bring the message back to Tony that Chulalongkorn is ready to be the co-host. As for Dr. Phawat, you also remind me of several work that we did together, including when we worked together so closely to defend or to our proposal that Thailand would play a host of the Asian Society of International Law biannual meeting. I think it was in New Delhi that we were together. And then you escaped when we organized the big event by going to do your PhD after you helped for everything already. But I'm glad that you are now a member of the workforce of Dean Parina. And I'm glad to see the effectiveness, as everyone said, of NUS. When I was president of the Asian Society of International Law in US, Simon Chesterman is the Secretary General of the Asian SIL, and I'm glad to see NUS and Chula are working together again today. Ladies and gentlemen, in the past 2 decades, international law has developed, strengthened, and at the same time weakened and overlooked by many from different walks of life. I believe the strength and weakness of international law application, teaching and practice is a result of changes in international economic, political, and technology landscape that evolves much faster than the making, than the teaching of international law. The superpowers' rivalry has undermined the respect for and development of international law, be it economic, political, or social bodies of law. The technology disruption and the pandemic spreading all over the world in the past 2.5 years, the grave concern on climate change, and the serious need for sustainable development, all of these have influenced over how international law role is perceived, how it is evolved, and how it is or should be taught. Ladies and gentlemen, international law has become interdisciplinary. Understanding other disciplines upon which international law is based has become key to our ability to analyze international legal issues. The relationship between international law and international economics, international law and world politics, international law and the political economy surrounding international law and technology advancement, international law and social changes. These relationships must form an important part of the teaching, research, and to form an important part of international law syllabus. The following changes and challenges would provide, I hope, fruitful thoughts for legal scholars, for teachers, and students of international law who further deliberate on how we can and should engage ourselves in the teaching and research on international law at the most important juncture of changes. They will demonstrate how interdisciplinary approach to international law is needed. First, there's a change in international economic landscape. That is the emerging new frontier of international economic law. I will not have much time to go into the detail, but just to flag out some of this emerging regional arrangement. The regional cooperation and integration starting from ASEAN. Years ago, we decided to have our objective of ASEAN community. We decided to have ASEAN Charter instead of only TAC, the Treaty of Amity and Economic Cooperations that have bound us together loosely for decades. So ASEAN has become more rule-based. A combination of rule-based ASEAN and the ASEAN way that has been practiced for over 50 years is indeed a challenge for the international law analysts. We are successful in having, at the moment, the largest free trade area of the world, the RCEP, the Regional Comprehensive Economic Partnership, comprised of 16 countries, but now 15 have been on board. 10 ASEAN countries, India, China, Japan, Republic of Korea, Australia, and New Zealand. And it is a comprehensive free trade, which is tolerated by the WTO, the World Trade Organization. India is not yet on board, but we hope that sooner than later, India will be on board, and RCEP, RCEP would be the largest free trade area of the world. Then we have the CPTPP, the Comprehensive and Progressive Trans-Pacific Partnership, comprised of 12 countries minus the United States. So some countries in ASEAN have been participating in the negotiation of CPTPP already. And the FTA, Free Trade Agreement of Asia Pacific, FTAAP, basically combining the RCEP, the RCEP, and the CPTPP together would be something that would be coming up. Thailand is a host of APEC this year, and one of the deliverables that we are going to advocate is to start a conversation, a constructive conversation on the free trade agreement of Asia Pacific. While we are waiting to see whether the United States will join the CPTPP, President Biden has not rejected CPTPP. But then last year, the Secretary of Commerce announced in Singapore and Malaysia. The United States will launch the Indo-Pacific Economic Framework, which is not a free trade area. It's more for economic cooperation. It will focus on the issue of cooperation on the supply chain that has been disrupted because of the trade war, because of the technology war, and so on and so forth. There are so many other elements in the Indo-Pacific Economic Framework as part of the Indo-Pacific concept advanced by the United States. We also have Mekong countries cooperation, the ACMEX, Ayeyarwady Chao Phraya Mekong Economic Cooperation. We have the Mekong Lan Chang, where Myanmar, Thailand, Laos, Cambodia, Vietnam work with China, work with the United States on the US Lower Mekong Initiative, with Japan on Japan-Mekong Cooperation, and with the Republic of Korea on Republic of Korea and Mekong Countries Cooperation. We have seen the emerging new financing for development. We have seen the BRICS Bank, New Development Bank, BRICS, Brazil, Russia, India, China, and South Africa. We have seen the AIIB, the Asian Infrastructure Investment Bank. All of this would add to the existing financing for development institutions like the World Bank, established after World War II, and the Asian Development Bank that Japan has been propelling the financing for development in this region through the Asian Development Bank. We have also seen the new monetary stability mechanism. The Chiang Mai Initiative, initiated in 1997 by ASEAN 10, China, Japan, and Republic of Korea, have been multilateralized. Of course, now the headquarters is in Malaysia. The Chiang Mai Initiative Multilateralization, CMIM, basically acts as Asian Monetary Fund, but we don't want to call it that. We don't want to upset our Western friends. We don't want to upset the Bretton Woods institutions, right? So we call it CMIM. Someone asked me why we call it like this, and it is so difficult to understand. So, well, because we don't want people to understand. We want to make sure that we are safe. We will not be pressured too much by those who advocated the Bretton Woods institutions. So when the CMIM has been launched with $240 billion reserve pooling, our currency has been relatively stabilized. The speculation against any currency in ASEAN has been dramatically reduced because, of course, China, which has the biggest foreign reserve, is backing. Japan, a developed country, Republic of Korea, Singapore, all of these developed countries, countries that have very stable currency, are backing the CMIM. We have seen the increasing role of the renminbi, the yuan, the RMB, first as a global reserve, as approved by the board of the International Monetary Fund. The proportion of the quota or proportion of the renminbi in the special drawing rights is next to US dollars and euro, overtaken Japanese yen and Great Britain pound. So the renminbi has been recognized as part of the global reserve. And China said that that's not enough. The Chinese would like renminbi to be a part of international trading company, although it's still very far from the US, which is leading at over 40% of the international trading currency for international payment, and euro as well. But it has taken over the Australian dollar and Canadian dollar already. So these are the change in the international economic landscape. And you can see that international regulatory regime dealing with all of this, either as existing law, either as a part of convention, a part of the treaty, or a part of what we like to call it the lege ferenda, things that may be the law in the future. Issues that may not be regarded as law, but it is bound by many. Issues that may not be yet regulated, but countries are committed to it. In ASEAN, I think the study of international law is very interesting. There are things that leaders sign declaration. There are things that we sign agreement, but to be very frank, it's not very much observed. And there are things that is not signed at all. And we decided that that's a good thing. The chemistry get together fine. The timing is right. And everyone followed it. And we call it nicely, Tony, that it is ASEAN way of doing things. So now we have this positive clash, if I may, between the rule-based ASEAN and the ASEAN way community. So not only financing for development, not only the monetary stability mechanism, the role of the renminbi as a currency, the regional cooperation, but the pandemic has changed the role or what should be the role of international law. A lot of literature on the reform of the World Health Organization and the fact that the World Health Organization did not do their job with due respect effectively in the first 6 months when the pandemic erupted. Now, everyone has agreed that we have to have a review of the global health governance. The issue of vaccine either is protected under international intellectual property rights mechanism, or it is a part of public goods. This issue of health diplomacy, food security, and health security. Secondly, there's a change in technology, everyone knows. Borderless transactions, while there is a lack of international regulatory regime of technology. We have witnessed financial technology, financial institutions providing technology service to clients. But at the same time, we see the technology company, which originally did not expect to provide financial services, but they have such a big database, a big data analytics of their clients. They decide to offer financial services to their clients, to their customers. So we have both fintech and techfin happening at the same time. From digital finance to something that many of us call decentralization of financial world. That is the blockchain, Bitcoin and cryptocurrency, bypassing commercial banks and central bank. And we've seen central banks starting or leading by People's Bank of China. And now the Bank of Thailand, the Thai Central Bank, have been adopting the same approach by, if I may call it, re-centralization of the financial world, embracing the cryptocurrency, blockchain, into what we call the central bank digital currency. If you ask me what is the international regulatory regime of all of this that we are talking about, it's very difficult to identify. And now we're entering into the metaverse, the NFT, the non-fungible token, that has extended from art pieces into almost everything at the moment. So you see that artificial intelligence, Internet of Things have changed the world. In various seminars, people have asked, what is the international regulatory regime of technology? And if we don't have one, the world will get into a bigger crash because of the technology war. We have 3D printing, which has changed the offshore investment into the reshoring investment. You don't need to invest in another country which has a low labor wages and then export it back to the market of developed countries. Because 3D printing, you can put the machine anywhere next to the factory. We have smart city, Singapore is leading everyone in ASEAN. We have smart farming that Thailand is working on very hard. Smart farming, precision agriculture, and as a result of the pandemic, telemedicine, which needs a lot of domestic and international regulatory system. We have the sharing economy, Gojek, Grab, Uber in the past. We have Airbnb, and Dean Parina would support me on that the Thai law is not yet updated to deal with the sharing economy. Although we said all the time that these are the type of business that we would like to support. But the Thai law is not 4.0, ladies and gentlemen. Thai law is 0.4. So we have to follow perhaps the model of Singapore, how Singapore can adapt herself to be a future-ready Singapore. If Thailand can be a future-ready Thailand, law has to be a part of it. And international law among ASEAN countries, international law among the regions would have to be enhanced. We have international trade with deliveries of goods. We have e-commerce, and we have international trade without delivery of goods or services. The Netflix stream, esports, how the international litigation can be brought for the practitioner of international law. We have concern of cybersecurity, and we have seen standards, international standards of business practices adopted by many international organizations. These business practices or these standards have been observed by actors in that particular business sector, in that particular business area, but they are not yet a part of any convention. They cannot perhaps be regarded as customary international law. Again, they may be soft law. What is the role of this soft law? Not the lex lata. This reminds me of years ago when I was at Harvard and I co-taught with the professor Frederick Snyder. This must be what, oh my God, I'm getting old, over 30 years ago or 40 years ago. So the issue of permanent sovereignty over natural resources and prompt, effective, adequate compensation once that is a nationalization had been the topic of thesis, research, papers. I'm sure, Tony, you've seen many of this all over the world. And whether the resolution of the UNGA on permanent sovereignty or natural resources can be considered as the existing law, only the law in the future, the lege ferenda. That issue may come again. We may not think about it, but if you look at the world of technology and the lack of international regulatory regime, this lack of international regulatory regime, the emerging of international regulatory regime that is not yet regulated to be accepted by the conventional international lawyers would be the subject of great research and debate. Third, there's a change in the practice of green economy, where business practice induces international law investment. Sustainable Development Goals, 17 goals, adopted at the United Nations. They have not become law, perhaps, but many countries apply. Many countries have applied the 17 development goals as the national agenda, including Thailand, and they have implemented them. We have seen COP26 in the UK lately. We have heard of political commitments to net zero and carbon neutrality, which all required, whether the leaders are aware of it or not, but they require domestic regulatory regime for you to get into the net zero and carbon neutrality. Especially along the way, the carbon credit and the trading of carbon credit is something that requires domestic regulations and at least regional agreement on how the trading can be done. We have the ESG, which is becoming very important in the business sector. environment, social, and governance. ESG somehow has enforcement, ladies and gentlemen, despite the lack of international law. It is the enforcement done by the creditors. Commercial banks around the world have said that if you don't have ESG, we will not give you the credit. The global fund, many of them, some of them belong to Warren Buffett and several other people, have said that we will not buy your stocks and shares if that particular company has no ESG. So that's why any company in the case of Thailand who got upgraded from B to AA to AA of ESG standard by the Stock Exchange of Thailand, their shares have gone up completely. Fourth, there's a change in political landscape, which applies international law to a conventional field. This political landscape is something that we thought that is already outdated. We taught the so-called public international law, and people said that the cases are not very up to date. But what I have witnessed is that conventional conflicts have become present day or modern conflict. The island dispute between Singapore and Malaysia, the International Court of Justice in 2008 awarded sovereignty over Petra Branca Island to Singapore. That was agreed. And politics has been depoliticized. But at the same time, there is overlapping claims in the South China Sea. The Philippines asked the PCA, Permanent Court of Arbitration, basically to be a secretariat to set up a tribunal. So the claim was filed by the Philippines against China. China, of course, did not accept the jurisdiction. So the issues of the jurisdiction of the tribunal to decide whether the tribunal has a jurisdiction or not became major issue several years ago. So the issue of the compétence de la compétence became the very important issue for international lawyers and scholars. I attended various regional and international seminars, conferences, discussing this particular issue. The issue of whether Taiwan should be invited by the tribunal to join because she would be affected by the decision. So the issue of the friend of the court, amicus curiae, became the issue of academic debate. I remember when I was in law school, when we studied territorial disputes, we had to refer to cases happened 40, 50, or 30 years ago. And then this South China Sea thing, I have to tell you that it's issue that APRC, Asian Peace and Reconciliation Council, that I'm the chairman, has been working on quietly for a long time. Because pending the agreement under the Law of the Sea Convention, the Law of the Sea allows parties to the conflict or overlapping area to enter into the provisional measure. Thailand and Malaysia for 40 years have entered into provisional measures on the JDA, Joint Development Area, of the overlapping claims in the Gulf of Thailand. And we are happy about the profit sharing. There'd been no clash between Thailand and Malaysia over the overlapping claims in the Gulf of Thailand. So APRC has been proposing quietly to those 4 ASEAN countries and China that have overlapping claim in the South China Sea, that why can't we look at examples between Thailand and Malaysia? In fact, there are over 30 examples elsewhere in the world, to see whether we can use the functional cooperation as an approach. Trying to work together, ranging from joint cooperation on maritime research, maritime preservation, to the joint tourism management, all the way to joint development area of oil and gas in the South China Sea. We worked on this for some time, and the result is a tiny one, but at least there was a result. They established a working group between ASEAN, both claimant state and non-claimant states of South China Sea, and China on environmental research. So if this can be elevated to the ministerial level, to the summit level, and move into something more constructive or substantive, leave the issue of sea boundary delimitation aside, maybe South China Sea can be a real sea of peace, freedom, and cooperation. I have to tell you that between Thailand and Malaysia, the sea boundary delimitation has not yet been finished. We negotiated the sea boundary delimitation every year. If we were successful that particular year, we play golf together. If we were not successful in that particular year, what do we do, Tony? We play golf anyway. So it is the spirit of ASEAN Way that perhaps can be applied to the South China Sea. Then this conventional field, the other issue came in 2013. Cambodia requests interpretation of 1962 ICJ decision of the Temple of Prof. The issue was so politicized in Thailand and in Cambodia. November 2013, the ICJ handed down the interpretation and said that the promontory belongs to Cambodia. So that's a very new word for Thai people, including Thai lawyers and my colleagues at the Foreign Ministry. You have to look up the dictionary, look at the court decisions to see what promontory means. And at that time, no one knew where is called the promontory at the Temple of Prof. Hill. So that was a subject of a great debate. It's a lively topic of international law research and teaching. There's a reference of the court interpretation to the UN Charter and to the work of other organs of the United Nations. The question was then raised whether international law was used to depoliticize political conflict or to repoliticize and escalate conflicts between Cambodia and Thailand. Fifth, the challenge is on the relevant role of the United Nations to the current problems in the world. The role of the UN Security Council, the UN of the UN General Assembly, the role of the UN Secretary General is a matter that are related to the threat to peace and security. For example, when pandemic COVID-19 hit us 2.5 years ago, there was a debate in the Security Council whether pandemic is a part of peace and security or not, whether it is beyond the scope of work of the Security Council. For months, Security Council could not reach any decision to get people to work together because there's been a debate on whether it is a part of peace and security. And for the layman, for the international lawyers around the world, people will think immediately, yes, it threatened peace, has created problems, boundaries were closed, people died, people suffered, and so on and so forth. Yet the mechanism regulated by the UN Charter is so strict that we have to spend time debating it. Whether we can have uniting, something similar to uniting for peace in the General Assembly, but let's have it like uniting for fighting against pandemic. Then the issue of Myanmar came when there was a coup d'etat last year in February. The UNSC condemned, but could not do anything much except saying that we support ASEAN to resolve the problem because that's a regional problem. And the UN Secretary General, as usual, assigned special envoy, Christine Bergener. She spent months talking to everyone except the Tatmadaw because the military government did not allow her even to enter the country. So that's the effectiveness of the UN system. And now we have a new person who is a former executive director of UN ESCAP. She's Singaporean, Noel Hoser. who is very good, and I hope that she would be able to visit. But you can see that the role of the UN is very limited. When a country is violating the issue or the principle of human rights, the principle of democracy, is a gross and systematic violation of fundamental human rights in Myanmar, at least in the first 6-7 months after February 1, 2021. Many civilians died, lethal weapons were used, but the UN system cannot do anything about it. And as we speak, and Tony touched upon it, I'm sure you'll spend more time to talk about Ukraine. The Russian-NATO confrontation in Ukraine is a real breach of fundamental principle of international law, fundamental principle of the UN Charter. I'm glad that last night, the United Nations General Assembly adopted with a vote yes of 145, only 5 saying no, and 35 abstained, to the resolution condemning Russia and demanding Russia to withdraw all the troops. But as we know, the resolution of the General Assembly is only a recommendation. It has no legal binding effect according to the UN Charter. It's a mobilization of change. It's a mobilization of pressure. It's a forum or platform to show the world opinion. But the world opinion has no bearings on countries violating international law, especially that country is a superpower. The UNSC was blocked by the veto of Russia. The same when other issues concerning issues of great interest to the Permanent Five, they will exercise the veto. So international lawyers, in international law and international organization law, we have been talking about reform of the United Nations. When there was an ASEAN candidate for the position of Secretary General, we were talking about this as well. Some of my friends have said to me that don't talk too much about the reform of the Security Council. It's a taboo. It's a subject that you will not be able to be voted by the Security Council. Because the United Nations, they want secretary, but not general. So if you want to be Secretary General, look at when Kofi Annan talked about the war in Iraq was illegal and see what happened to him and his family. So certain years past, we can talk about it, but this is an academic conference. These are real politics surrounding international law. It's a national interest of each country that's been injected into an international regulatory regime. This is not new, but I think it has intensified. And we have to understand the real politics and help each other finding ways to deal with it. If the UN system is near crippled, is near being crippled, how we can make UN and its organs, World Health Organization and others, to be more effective. What kind of legal amendments can be done? What kind of strategy that we can involve stakeholders, countries large and small, to see that there is a need, a serious need for the reform of the United Nations if the world would be a safe place and peaceful place we would live in. I'm sure that with this issue of the military incursion in Ukraine, the issue of the law of war, conditions which states may resort to war, the jus ad bellum, and the law of war, which regulates conduct of parties engaged in an armed conflict, or the jus in bello, will become topics of teaching, debate, and research. Sixth, there is a re-emphasis of internationally accepted norms and standards, where we see the increasing role, which I'm glad that we are witnessing it, increasing role of international law, increasing role of social value, increasing role of human value, an increasing role of the rule of law, something that not much cited in the study of international law. International law, social value, human value, and the rule of law interact each other in the newly emerged or the re-emphasis of internationally accepted norms and standards. And they are democracy, human rights, governance, ESG, environmental social governance, objective of green economy, where each country has her own model, and also the sustainable development. So I think these are things that international lawyers, scholars would have to, again, put our act together and see what is the legal aspect of the re-emphasize or the re-emphasis of these norms and standards and how it should be developed. Some areas has become a part of international law. Some areas, international legal basis is not very clear. Some of the area, especially the environmental protection and sustainable development, still waiting to see how the law can be implemented. Ladies and gentlemen, in the past 2 decades and the past decade until present, there have been many challenges on the application of international law to many issues, as we discussed, which have led to challenges in the teaching and research of international law. The increasing interdisciplinary component of international law is what has shaped the understanding, the teaching, and the research of international law. The world situation has brought about yet the conventional area of conflict, the non-traditional area of conflict, and the new conflicts which challenge international law and the rule of law. However, there has been factors affecting the development of international law teaching and research. The lack of interest among students in international law is something that we have to admit, comparing to the so-called business law. The general feeling or perception that international law is a matter of only for the academics, judges, and diplomats. The perception that international law is far from affecting day-to-day life because they don't understand the interdisciplinary nature of international law. The fact that the relationship between international law and peace and security are not reported in the news to reflect the relevance of international law. The insufficient resources from academic institutions to support the teaching and research of international law. That's why I'm so glad that Faculty of Law at TRILA University and International Law Center in the US are working for many years now on this TRILA. There's also the lack of awareness of some academic administrators of how important and how relevant international law is for academia, for livelihood of the people, and for peace, security, and development. And worst of all, the lack of observance of international legal order, sorry to say, by superpowers. The wrong notion of might makes right, rather than right makes might. All of these, ladies and gentlemen, have contributed to a small or large extent to the challenges of the development of teaching and research of international law. In conclusion, the challenges that I have identified are in themselves, in my view, opportunities for expanding and deepening the teaching and research of international law. The reality has been that international law in all fields has evolved, has been practiced, and has awaited to be applied, to be practiced and to be further developed. There's been a call for international regulatory regime in various areas, in various factors. from many policymakers that have met, internationalists, and stakeholders. The case of technology is a good example. There's been a clear intermingled relationship between law and other disciplines. Which way we should go? Trying to separate law from other disciplines, or to understand the interdisciplinary nature of international law of today and make our teaching and research reflect the reality of the world we live in. It is therefore incumbent upon all of us, academics, international law scholars, whether we can put our act together to turn challenges faced by international law into opportunities of teaching and research for the benefit of peace, security, development, and of mankind. Thank you very much for your attention.
Thank you very much, Professor Surakiart, for such an enriching and inspiring notes and food for thoughts. I'm sure a lot of us has difficulty taking notes because there are so many issues in his speech, which indeed, of course, expand and broaden our understanding and the way we look at international law and especially how we prepped in the future for the course of public international law.